And Joe DiGenova is with us as well, former U.S. Attorney for the District of Columbia and a member of President Trump's campaign legal team. Joe, good morning, sir.
Good morning, everybody, and Merry Christmas.
Merry Christmas to you. Well, I know that the Trump campaign is hoping that SCOTUS is going to give them a Christmas present, and justice will be done. The President's campaign committee filing a petition for writ of certiorari to the U.S. Supreme Court, asking to reverse a trio of Supreme Court cases at the state level from the Pennsylvania State Supreme Court, which illegally changed Pennsylvania's mail balloting law before and after the 2020 presidential election. That a campaign statement from Rudy Giuliani. Joe, what can you tell us about this Supreme Court petition that's been filed?
Well, this petition was put together by John Eastman, who is a renowned constitutional scholar and has written extensively on the Electoral College and federal elections. It requests the Supreme Court to take up once again the three cases which came out of Pennsylvania, which involve unconstitutional changes in state election law dealing with absentee ballots, with the exclusion of Republican poll observers from the review of over 680,000 votes sufficient to overturn the election, and a number of other issues. They also challenged the state election law, which was enacted to change mail-in and absentee balloting in violation of the Pennsylvania Constitution and the Equal Protection Clause of the United States Constitution. It's a very, very well-written petition for certiorari. We shall see whether or not it is successful, but Eastman is a really fine constitutional scholar.
You know, Joe, the president had said, Trump's the case. Trump had said that Texas was the case. The Texas case was going to be the one that was going to get heard by the Supreme Court, that was going to break this wide open for him, that was going to give them that foothold that they need. That didn't happen. They chose not to hear the case. And I have to tell you, I just almost feel like they don't want to. They don't want to get involved in any of this. I feel that way with the Supreme Court. Is that what we're seeing here, or was the Texas case not what the president hoped it was going to be?
Well, you can't blame the president. He's a client. The clients have all sorts of expectations. He's not a lawyer. He's saying things that any client would say, and I think his expectations are actually quite reasonable. Okay. I'm somewhat perplexed by the decision of the Supreme Court not to take the Texas case. But that said, I've been perplexed by the court's refusal to review the Pennsylvania cases, where there are clear violations, not only of Pennsylvania Constitution and state law, massive violations and tremendous amounts of evidence of unconstitutional ballots being counted without Republican poll observers being present. Under Pennsylvania law, every one of those ballots which was counted without a Republican observer being present is null and void. And yet the Supreme Court is not taking these cases. Perhaps with the magic of John Eastman's brilliant writing, they will grant cert and will grant expedited briefing in the three cases that the president has sent to the court. Certainly, the president has standing since he is the candidate and he has been harmed by the election results in Pennsylvania. So I'm not sure they can dismiss it because of standing. So I think he has a better chance now than he did in the Texas case.
Just to follow up to that, Joe, it just seems to me, and I could be reading it wrong, it seems to me that the courts in general are loath to get involved in this. They don't want to open up a can of worms, and they're like, yeah, we'll fix it for the next time. But they don't want to overturn an election or declare that you need a do-over, another bite at the apple in certain states. Am I reading that wrong?
Then why have laws?
I agree.
Why have election laws? Why have the Constitution? Why have state constitutions? If not these cases, then which cases and when? For the future? For those of us who support the president and are assisting him in this legal battle, this is the future. The future is now, as the famous coach George Allen used to say of the Washington Redskins when they were called the Washington Redskins. The bottom line is this. These cases are, in fact, ripe for adjudication. The Supreme Court should have heard these cases, and the fact that they are not hearing them does, in fact, look like they're kicking the can down the road. And it's unfortunate because what it does is it makes people think that recourse to the courts is useless. We don't want people thinking that. It's not a good thing. We want people to resort to courts. We don't want them to say, I'll handle it another way.
Well, and to that end, Joe, I mean, let's ask about the calls that we've heard for the president to declare martial law in
that's not
7
going to happen.
states
That's
over
not
the
going to
weekend.
happen. No, that's not going to happen. He's not going to declare martial law. What he is going to do is he's filed this case in the Supreme Court. He's also going to be working with 4 or 5 state legislatures to get them to call themselves into what's called electoral session, not special session. The special session requires the action of a governor. Electoral session only requires that the state legislatures on their own call themselves into session and send a group of electors on January 6th to Congress to challenge the electors which have been certified by the governors in 4 states. That's what they're concentrating on. That's what the campaign is concentrating on. And also it's concentrating on trying to challenges to voter rolls in various states and to get subpoenas to look at computers, for example, in Arizona, challenging the voter rolls in Georgia. So it is an active legal campaign which has not stopped, notwithstanding reverses. So we shall see. But, I applaud the president for doing what every American is always told to do. Play by the rules, use the legal system, vindicate your rights. That's exactly what he's doing. And for him to be criticized for that, I think is just ridiculous.
He's not doing anything illegal. He's using the means that he has available to him. You mentioned January 6th and going with the electors. We have Mo Brooks who said that he will object to electors. You have now you have Matt Gaetz saying over the weekend that he will object to electors from states that didn't run clean elections. They still need someone from the Senate, and we know that Mitch McConnell basically put out the word "do not object" because you're going to harm. You may harm some of your colleagues, meaning that it may be hard for them to get reelected, I guess is what he meant. Are there any senators that we know of who have said that they will object to electors on January 6th?
Not yet, but I think there are several who said they are considering it, such as Ben Sass and Ron Paul and Josh Hawley, and I've heard several other names. It's very difficult for me to conceive there's not going to be a single United States senator who's going to join forces with 3 or 4 Republican members of the House to call in questions electors from various states, from the 4 states that have always been at issue, and then force a debate in the joint session on January the 6th. So we shall see. I think there are going to be some senators that are going to step up.
No, I hope so, and
it has to be in writing. Of course, there has to be a letter signed by the member of the House and the member of the Senate for the objection to be legitimate. You will recall that in 2000, a number of Democrats got up and objected, but because they did not have a single senator supporting them in writing in a letter, all of those objections were overruled by none other than Al Gore.
Well, I have to tell you, that sounds like something Republicans would do. We've got more with Joe DiGenova coming up.
Talking with Joe DiGenova, former U.S. attorney for the Washington, D.C. area, also member of President Trump's campaign legal team. And, Joe, we've been talking about what might happen on January the 6th in terms of those challenges to electors. President Trump over the weekend tweeted out talking about a protest scheduled for January the 6th. He says, quote, statistically impossible to have lost the 2020 election. Big protest in D.C. on January 6th. Be there, will be wild. What kind of turnout do you anticipate from the American people as Congress gathers on January the 6th, and we might see those electoral challenges in the House and Senate?
Well, I don't know anything about the legitimate First Amendment protest that the president is predicting, but I think without any doubt, given the level of support for the president, which is over 74 million votes, the largest amount of votes ever cast for an incumbent president in a general election, I think whatever protest occurs will be gigantic. The support for the president is unbounded and unwavering, and I think it's going to continue while these legal challenges proceed through January 6th when the votes are tabulated for president. But I think that the president's vigor in defending his position is something that people should praise and be proud of. And I think the president is right on about the nature of the election. I think that all of the available evidence, which now includes thousands of affidavits and statements, sworn statements, statistical evidence from analysts and other problems, there's just no doubt that in those 4 states, which are the subject of the ongoing litigation, the electoral anomalies are so stark and so obvious that there needs to be an assessment, there needs to be relief from the Supreme Court, and I think it is legitimate to challenge the electors from those states on January the 6th.
In Georgia, you had mentioned voter rolls, Joe. In Georgia, the County Elections Board dismissed challenges to the voter rolls, saying Jason Shepard, who's the chair of the GOP in Cobb County, said they found evidence of over 16,000 people registered to vote in the county who reside outside of the state of Georgia. Is this just to buy time to try to push it down the road so that it gets to the point where it's too late for the president to do anything about it?
Yes, the Georgia officials are in a rope-a-dope defense posture because of the manner in which they carried out the election and because of the manner in which the Republican stakeholders running the state, the Secretary of State and the governor, both Republicans, issued into a settlement agreement with Stacey Abrams and the Democrats and the ACLU, which basically stripped Georgia of its ability to credibly verify mail-in, mail-out, and absentee ballots. And so what they're doing now is they're doing everything they can through these state election board, county election boards to thwart any analysis of the votes, including signature matching, verification, and everything else that goes along with that. Now, ask yourself this question. If you were truly interested in a transparent election, why wouldn't you go along with such a request? What is there to hide? And the answer is a lot.
Yeah.
Well, and I mean, speaking of transparency, let's talk about what's going on in Arizona, because Maricopa County supervisors on Friday decided, well, we're not going to comply with a subpoena for election materials. We're going to go ahead and try to resist this subpoena. If you want transparency, then why not provide access to the Senate Judiciary Committee the information that they want to ensure that the vote was honest and accurate?
Well, there's no reason you wouldn't comply. First of all, it's a subpoena, so they have to. So presumably there's going to be litigation over that, which of course which will be done for delay. But the subpoenas demanded access to copies of more than 2 million ballots cast by Maricopa County voters in the election, and for access to the equipment used to tabulate those ballots and the software that ran the equipment. The board, by 4-1, refused to turn over that information, saying they feared it would lead to the exposure of voter identification information. Well, that's nonsense. You can get protective orders for all of that stuff. That doesn't lead automatically to the disclosure of private information on voters. That's ridiculous. This is a delay tactic which has been used all over the country by the major counties where all of the fraud occurred and the irregularities and the illegalities and the computer problems. So this is just a delay tactic, and unfortunately, they may succeed.
But 3 Republicans voted with the majority on that. 3 Republicans and 1 Democrat voted to refuse. What's happening?
Yes. Well, there are not a lot of profiles in courage out there at the state level. As you have watched this evolve, one of the things that has been in stark contrast to a solid wall that the Democrats have put up everywhere is the kind of porous wall that the Republicans have been able to produce at the state level. There's been some notable exceptions to that. For example, the Republicans in Georgia at the fighting level, at the level of not the governor, below the governor and the Secretary of State, the Republicans in the legislature have been fantastic in Georgia. They've also been fantastic in Arizona. But on these boards, these local boards and things, the Republicans have played a very, very corrosive role in assisting the president in a legal challenge. It's been very depressing and hard to watch. And I probably politically in the future, there's going to be hell to pay for a lot of those folks.
Yeah, I would think so. Joe, again, we had so many more questions we didn't even get to talk to you about, but thank you so much. I really look forward to getting to talk to you, and I know our listeners do too.
Merry Christmas.
Merry Christmas to both you and Victoria. Thank you so much.